Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So we received an interesting inquiry here on our YouTube channel. Let's see right here. It says right here, it has to do with theft of a car under the influence of drugs. Let's see here. My 17-year-old son, a minor, is addicted to drugs. One night, he assaulted a person and stole his car. When fleeing, he hit a cyclist, and he kept going until he was arrested by the police. Okay, well, off the bat, that's a carjacking. If somebody's in their car and you use force or fear to take the car from them, this would be a violation of Penal Code Section 215, which carries up to 9 years in state prison. Now, because your son is a juvenile, he's 17, more likely he's not going to go to prison, but he could still potentially serve that time in a juvenile correction facility. Now, it says right here that he hit a cyclist and he kept going. Well, that's a hit and run. More likely a cyclist got hurt. That would be a felony hit and run under Vehicle Code Section 20001, which carries up to, 3 years of state prison. Now, he was running from the police until eventually he was stopped. Well, you're putting people's lives at risk, so that would be a felony evading the police. That's a violation of Vehicle Code Section 2800.2, which carries up to 3 years in state prison. When you're running from the police and you're risking people's lives, that is a felony. Now, it says right here that the 17-year-old was addicted to drugs and he was under the influence of drugs when he did all this. Tough. If the 17-year-old wasn't kidnapped and forced to take this drug, that's not going to be a defense. Voluntary intoxication is not a defense. Oh, it's a mitigating factor to get less punishment when you're doing a deal, when you're cutting a plea deal with the DA's office. Oh, sure. But it's not an actual defense to the crime. So if you try to take this case to trial, you can't say, well, he was under the influence. I'm like, who cares? He himself got himself high, and anything he does while he's high, he's going to be responsible for that. Fortunately, because he's a juvenile, he's not going to have to bear the brunt of full responsibility like an adult, but still, he's going to have to be responsible with this. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation, give us a call for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who was arrested and then released. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.